Greetings, class. Today we're going to talk about the IRAC method, explain why it's important in our legal research and analysis process, as well as when we end up writing legal memoranda, and then explore the components and practice how to apply it. IRAC stands for Issue, Rule, Analysis, and Conclusion. These are important components of the way we approach analyzing a case and then presenting that case in writing via a persuasive legal memorandum that we would file with the court or an objective legal memorandum that we would write for our boss to analyze the chances of success on a case. Well, why is IRAC important and why should we go through these steps of identifying the issue, rule, analysis, and the conclusion of the case? Because the process itself actually helps us determine what issues need to be resolved. Then it helps us identify what legal and factual research is necessary to be able to fully analyze the case and reach a conclusion. So this process will help us logically think about a case and outline all of the legal and factual basis for our conclusion. Let's start with discussion of the issue. This is the question that needs to be resolved. Sometimes there's an overall issue, the big question, like did someone commit a crime? Did someone commit a burglary? But then we're going to see that there are sub-issues, components that have to be answered before we can answer that general overall question. Issues themselves are actually driven by the law and the facts. Oftentimes there's a legal component to a question and a factual component. So I find that especially as you're starting in your legal studies career, the best way to approach writing an issue is to include a legal component and a factual component. And I call it the law when fact formula. So you'll see in the blue, that's the legal component to the question. Was the defendant negligent? That is the legal question. But we can't answer that in a vacuum. If I just said to you, was the defendant negligent, and you didn't know any facts, how would you be able to even guess what the answer to the question would be? So we have to put the legal question in the context of the facts. We can do that by literally using the word when in a sentence and then adding on the facts that help drive the answer. So it makes a lot more sense, and you as the reader can kind of figure out where something is going if I ask the question, was the defendant negligent when she was texting as she collided with the rear of the plaintiff's vehicle? That factual context is important to writing a good legal issue. The rule is the rule of law. This is the legal authority. We want to focus on primary legal authorities, which are the Constitution, common law, statutory law, and regulatory law. Remembering back into the earlier weeks, common law is created by the courts, statutes created by Congress, and regulations are enforceable and created by the executive branch. Our job when we're doing the IRAC method and when we're doing all of our legal writing is to identify the rule of law, explain that rule in detail, give examples of how the rule has been applied in other cases, and always, always, always cite to legal authorities for every component of your rule. The analysis. This is where you actually apply the law that you've researched, the rule, to the facts of the case. This is where you explain logically why you reach the conclusion you will reach. You have to be sure to address each element and sub-element of any of the rule in your analysis. If you leave any component out, there will be a break in your logical chain. You want to always in your analysis explain why this matter is similar or dissimilar to precedent, because that will control the outcome of the case. The conclusion. This is the outcome of your analytical process. This often can be the thesis statement for your legal memorandum as well. Now, let's take a scenario and practice how to use the IRAC method. I'll read through this. It's kind of a long story. Woogie worked with Mary and had a crush on her, but Mary never really paid any attention to Woogie. So Woogie took to following Mary home in his car after work. She lived in College Park, Maryland. He would park along the sidewalk outside her home and watch her inside through high-powered binoculars. He regularly kept a journal of Mary's activities in her home, such as MMA workouts, and he would annotate the journal with his feelings for Mary. At 6 p.m. on November 1st, 2020, Woogie saw Mary changing in her bedroom and was effusive in his notes of love for Mary in his journal. He wrote, quote, "I am determined to make love to this amazing woman. I will do it at any cost and it will happen tonight." End quote. He put his journal in his back pocket, left his car, and proceeded to Mary's front window. It had no screen and it was open about 4 inches. Woogie pushed the window open so he could fit in and climbed into her living room. He made messy, muddy footprints on her white carpet. He made his way upstairs to Mary's bedroom, where he startled her when he declared, "I love you so much and I want to show you physically how much I do." Mary approached Woogie, punched him in the gut, and kicked him in the head. Woogie immediately ran away. A neighbor was coming as he emerged from the house, so he ran down the street instead of to his car. Mary called the police and told them he must have come in through her rear window because she had left it open a few inches. The police scoured the area. They found Woogie's journal in the neighbor's yard and a man in the bushes. When they shined their flashlights on the man, they realized he matched the description Mary had provided. They arrested Woogie and he was charged with common law burglary. Their investigation yielded muddy boot prints that matched Woogie's on the white carpet under the open window and Woogie's fingerprints on the inside and outside of the window frame. They also saw that the window was fully open. State records revealed that Mary's name was on the deed to the house and there were no other owners. Your boss is Woogie's defense attorney. She asks you to research common law burglary and determine what the likelihood of Woogie being convicted of burglary is. So you're sitting here with this big problem and you have to figure out, well, how am I going to attack it? Well, the best way is to start with the IRAC method. This will help you determine what the issues are and will help you target your research. Obviously, you know that burglary is going to be the major issue here. So you need to start with some research and figure out, well, what is burglary? What's that definition? So let's look at our overall issue. Let's just start with the big part. Did Woogie commit a burglary? That's our big legal question, but we're going to put it in the context of the facts. I'm going to come back to that in a little while. So there's some things here that you wouldn't know off the top of your head, and that's the column about the rule of law. This is generally when you have the overall issue, did Woogie commit a burglary, is where you're going to start with your research. Your job is to determine what's the rule of law related to burglary. What is a burglary? So if you went to the law library and you research burglary, you would find a definition of common law burglary. And it's literally the breaking and entering the dwelling house of another in the nighttime with the specific intent to commit a felony therein. So that means that there are a lot of components to this definition, and it is often useful to break those down into elements. Elements of crimes are frequently referred to in jury instructions even. So when a judge is instructing a jury, the judge will literally instruct the jury that says that the elements to the crime of burglary are that there has to be a breaking, the next element entering, the next element dwelling house, next element of another, next element of nighttime, and the next element with the specific intent to commit a felony therein. So these are the elements of a burglary. And these are going to really be all the things that have to be proven by the state beyond a reasonable doubt, if you remember back into your week 2 module, to prove that Woogie was guilty of a burglary. So this is where you say, okay, can I answer these questions? So the first issue is, well, did Woogie break? Well, you have to know what breaking is before you can answer that, right? So when we look into our research, that means we have to delve further. So you go to the law library, you do research, and you determine, well, what's the definition of breaking? You find a case that was the case of State versus Smith, in which the court determined that using force, no matter how slight, to gain entry is a breaking. The Court of Appeals ruled that pushing a door that was slightly ajar further open constituted a breaking in a burglary case. Well, that's a whole lot of information that we need to be able to now analyze the facts of the case and reach a conclusion. So here we know that Woogie pushed a window that was slightly ajar open further so he could fit inside the house. We have evidence of this because Mary has a statement that she left the window open a few inches and the police found the window fully open. Furthermore, Woogie's fingerprints were on the inside and outside of the window frame. This illustrates that Woogie pushed the window further open to gain access inside the house. And just like in the case of State versus Smith, taking an item that was ajar and pushing it open further shows that there was a breaking, and that can be your conclusion. So once we have the rule and we analyze it and we reach a conclusion, this is actually when we can go back and better finish our issue. Here we can now put the issue in context because we know what facts are important to the outcome, to answering the question. So here we say, did Woogie break? That was what we started with. Now we can put in the word when and say, did Woogie break when he pushed a cracked window open further to gain access to Mary's house? This will help fully analyze this particular element of the crime of burglary. And it's now our job to be able to move on and do this analysis, the IRAC, for every single element of burglary. Now, remember, when you're doing your issue, you want to have the legal and factual component. When you are writing your rule of law, you want to make sure that you fully define the term, provide an example of that term as it was applied by the courts, and very, very importantly, every time you reference the law, you need to provide a citation to your authority in Blue Book form. And we'll talk about that citation format a little bit later in this course. With regard to your analysis, this is the important part. Your job is to describe the physical evidence, the testimonial evidence, and circumstantial evidence that relate back to the definition of the element that in the rule. So you have examples of how it's been applied. You can also show how the examples are similar or dissimilar to show that the defendant was guilty or not guilty of this particular element of the crime. Your conclusion, there was a breaking, is ultimately going to be your thesis when you are writing an analysis paragraph with it. So literally, your thesis could be a reframing of the issue even. So you could have a thesis statement that said, Woogie broke when he pushed a cracked window open further to gain access to Mary's house. So your issue and your conclusion are often very much aligned, and your issue can actually turn into a great thesis statement by simply changing it from a question to a statement. So now what I'd like you to do is to practice. I am going to ask you to complete the rest of this chart and fill in all the components that are missing, including in your issue and your analysis and your conclusion. Don't worry about doing the research and the citations in this part of the class. We'll assume that that is accurate and that there are citations there. You're going to get into the research and citation component a little bit later in the term. Then, after you complete this, in a few days, I will be posting a fully completed chart, and you can compare your analysis to an analysis that I have completed. I hope that you find this helpful, and I would encourage you, even though it seems like it takes a lot of time, to use this approach when you are doing your research to almost every question of law that you will have. This is a great way to make sure that your logic is complete, that you don't have any gaps in your research, and you don't have any gaps in your factual analysis.